and welcome to Legal Affairs. My name is Diamond Liddy, and I'm the public defender of the 19th Judicial Circuit. I am very proud to introduce our guest on today's show. With us, very proudly, is Armand Murach. I always worry if I'm pronouncing that
You're pronouncing
correct.
it perfectly.
Okay.
Yes.
Who actually works for the Office of the Public Defender of the 19th Judicial Circuit. But the reason Armand is on our show is because he just got a promotion and he is in charge of the juvenile division basically for the whole judicial circuit. Certainly he is the head supervisor for the St. Lucie County office, but he oversees what goes on in the juvenile division in the 4 counties. So Okeechobee, St. Lucie County, Vero Beach, and Martin County. So welcome.
Thank you, Diamond. Pleasure to be here.
Armand, let's start with some background, and then I'm going to ask you some kind of pointed questions. But let's start with your background. Where'd you come from, schools, that kind of thing?
Originally, I'm from New York. Then I moved down here when I was about 8 years old. Went to school down in South Florida, in Miami. Graduated with about a lot of different degrees. I was trying to figure out what I wanted to do when I was in college.
Well, tell us about that. I don't know if I knew about that.
I went to Florida International University,
right,
where I was studying computer science. I wanted to be involved in computers. Didn't really want to do anything else, or was sort of a shy kid. So
right,
wasn't a public speaker or anything
right,
like that. Then started getting interested in politics.
Okay.
So I switched majors to political science.
Okay.
And then couldn't decide if I liked international politics or just, homegrown U.S. politics.
Right.
So I ended up getting 2 bachelor degrees.
Oh, okay.
One in international relations, one in political science. At that point, I still didn't really know what I wanted to do. Most political science people end up getting their PhD or going into teaching.
Right.
Which I was, being torn both ways. But my family sort of wanted me to go into business because that's, they wanted me to be a businessman, basically. So I went and got my MBA at Nova Southeastern University.
Right.
Now, throughout the entire time when I was going through that, I sort of wanted to be a lawyer. I had lawyers in my family. My half-sister's a lawyer, but my family was really against it.
Why?
My family doesn't like lawyers.
I love it.
So I got the MBA to get my dad off my back so I could,
right,
do what I wanted to do after that. After I got my MBA, I still had the desire to become a lawyer.
But you're young. I mean, how young were you when you got all these degrees, Armand?
When I graduated from FIU, I was, I think, 24, 25.
Right.
Then I got my MBA, I think I was at that point 26.
Okay.
So I know I was young at the time, but I sort of grew up really quickly, and I was, a lot of people used to call me an old man when I was in high school. So I was always making serious decisions and wasn't sort of, trying to jump back and forth.
Right.
So I had that desire and decided to go to law school. So luckily, I liked going to Nova. I loved their campus.
So did your family disown you, or were they okay with it?
They were okay with it because I basically made a deal. It's like, you don't have to pay for anything. I'm going to cover my own way through law school. Don't worry about it. I'm not going to be a professional student. This is the last thing I'm doing.
Okay.
So they said, okay, fine, whatever you want to do it. Went to law school, and then that's sort of where I discovered my love for litigation and just wanting to be someone who does talk, which was ironic for me at that point. Went through law school, worked at a lot of different firms trying to figure out what type of litigation I wanted to do. At first, I thought I was going to be sort of a jack of all trades. So I was going to do every type of litigation because there wasn't anything that I really didn't like doing.
Right.
Sort of realized that that's not practical in the legal community. And a boss told me that you don't choose the field of law you're going to do. The field of law chooses you.
Oh boy, that's poignant, and that is true.
Yeah.
That is true. So go ahead. I'm sorry.
So after that, I graduated law school, was able to find a job pretty quickly in a legal field or legal profession that was sort of in a recession at the same time. The country was in a recession.
Right.
And I was doing some civil litigation work, Did that for about 2 years, and then decided not really the field of litigation I wanted to do. I was looking towards more.
Well, did you ever, going back, did you ever have a trial in the civil arena? Because trials in all arenas now, unfortunately, are kind of dwindling, but civil certainly more than criminal.
Well, I think I prepared for more trials than I can count in civil litigation, and I went to trial 3 times in civil litigation. Usually it's because it was a contract dispute or a family issue or something like that, where no one was going to, settle or want to negotiate anything no matter what. So it's one of those, well, I'll go along with it because you want me to, but it's going to be a long, hard fight. So I was able to get, luckily, three trials when I was in civil litigation.
Wow, that's more than most. Yeah. Okay, so then what happened?
Then I sort of started realizing, well, I have that strong passion for litigation, but civil litigation, like you mentioned, there's not a lot of trials that happen forward, and you don't really spend a lot of time in a courtroom. I've known a lot of people in the civil litigation world that actually hated going to court because it took them away from doing their work that they had in their offices.
Right. Or don't feel comfortable with the courtroom.
Exactly.
I mean, it's not the place where they have their comfort level,
And for me, it was the opposite. I felt the most relaxed in a courtroom than anything else. I felt that was my arena. That's where I could be myself and not stress out over anything.
Wow. That is unusual. I mean, not to interrupt you, but that you do realize that's not the norm.
No, I know. I know that's not the norm. That's why I don't fit the mold of a lot of young attorneys when I was interviewing at different firms. They didn't understand, well, why do you want to be in a courtroom? Oh, you don't really know what you're doing in a courtroom, or any type of question like that.
Right.
But it was something that I sort of almost obsessed with during law school and just tried to learn as much as I could.
Right.
And luckily had a great number of mentors over at Nova Southeastern University that helped me hone my skills.
Right. But you didn't like the civil litigation, so we got to segue into how you came to work for the public defender's office.
Well, at that point, I started looking into working in a public defender's office or a state attorney's office.
Right.
And applied at the local offices down in South Florida where I was, and then a friend of mine told me about your office and told me about the work that the 19th Circuit does.
Right.
And how it's sort of different and more unique than some of the other offices in the state of Florida. That really enticed me, and I think it was then sort of late in the hiring process, and I was basically rushed to do an application, and I think I spent all night finalizing all the paperwork to file it in, and hoped to have a chance to interview with you.
Yeah. And then you got hired.
And then I got hired.
But let's back up a little bit, again, because it's impressive. You are still working, so to speak, with Nova because with the trial advocacy program. Tell us about that.
Well, after I graduated, I was lucky to be given an opportunity by my mentor, Professor Mark Dobson, to coach a mock trial team with him. Now, I took that very seriously because I know they only ask seasoned litigators to do that kind of work with them.
And explain for the viewers, what is a mock trial?
A mock trial is basically in law school, a way of training law students because they don't get significant trial experience to learn all the aspects of a trial, how to do a direct examination, an opening statement, everything that you basically see on TV, but to know the sort of the significance of how to do it the right way and as opposed to the wrong way.
Right.
So they learn all the basic skills that they would learn or they should know so they can actually try a case as soon as they graduate from law school.
Okay. And you're still doing that. You're still involved in that, aren't you?
I think this is my now 4th or 5th year. I've lost track of how many times I've done it for him.
So you train other lawyers is the bottom line.
Yes.
Good for you. Okay, so you get hired as an assistant public defender in the 19th Circuit, and you're in the juvenile division.
Yes.
Okay. Yes. And you've basically stayed, gosh, I lose track. that's basic. Did you ever move into the misdemeanor division for a period, or no?
No, I moved straight from juvenile to felony in Okeechobee County.
Right.
Before coming back to St. Lucie County to be the supervising division head of the juvenile division.
Okay, so you've had juvenile experience and felony experience. What is the most? Explain in a nutshell, I guess, basic. Well, I can do that. The major difference between the juvenile division and handling cases in that, and felonies or misdemeanors, is that a juvenile trial is a judge trial, correct?
That's right.
Okay. So let's compare the two. Let's compare juveniles cases and handling felony cases. What cases do you find the most challenging?
The most challenging cases, especially in juvenile, are what we would say are sex offensive cases.
Right.
Cases that involve, as you sexually motivated offenses or involve actual just sexual contact between children or between victims and adults.
And why do you find them the most challenging, Armand?
They're the most challenging because, as opposed to the differences in terms of punishment for a child and an adult, there is no difference for most cases between what type of punishment there would be for a child and adult, meaning sex offender registration.
And again, explain what sex offender registration is.
Well,
let's back up. So you're telling me that whether you're a juvenile or a convicted felon adult, you can still be ordered by the court to register as a sex offender.
yes.
Okay, and that's a big deal. So explain that.
Okay. So sex offender registration basically means that if there's a qualifying offense such as sexual battery, lewd and lascivious battery, and a list of other types of offenses that are related to a sexual incident, a person would have to register, and in the state of Florida, that would be with the Florida Department of Law Enforcement,
Right.
where they keep a registry of everyone that is listed as a sex offender. Once that list is created, anyone can go on and search their neighborhood to see if there is someone who's been previously convicted of one of those type of offenses. So it creates a significance because it stays with the person for their entire life.
And can you ever get off that sex offender registration list?
Well, as a child, you have the ability of getting off that list, I believe, but it takes several decades, and there can be no offense, no criminal history, basically no traffic ticket almost.
Wow. And so for an adult, then you're on forever.
You're on forever, yes.
And for juveniles, you can possibly get off after 20, 30 years? Or
20, I think it's either 20, 30, possibly 40 years. It's several decades that you would have to be on the list before you can get off.
So a 15-year-old can be a registered sex offender?
Yes.
My goodness. Okay, in handling those cases, is that negotiated with the prosecutor, Armand, or is that an automatic judicial requirement in some cases? I mean, explain that difference.
Well, for juveniles, luckily there's several outs to try to avoid having to register as a sex offender. The first one, statutorily, if you're under the age of 14, 13, you wouldn't have to register as a sex offender because the legislature has deemed it to be that you were too young to really understand what you were doing.
Okay, if you committed one of those qualifying offenses,
yes.
Right? Okay, so go ahead.
The other sort of exceptions that are somewhat different is that there's some offenses like lewd and lascivious conduct.
Okay.
For an adult, they would have to register, but for a child, they wouldn't.
Okay.
And then the third other difference is, since the state of Florida has what we call a withhold of adjudication, for juveniles, if they have a withhold of adjudication, that wouldn't require them to register either. But for an adult, they would have to register.
Okay. But again, you could be, give me, obviously you think that, as you said, these are the most challenging. Give me an example of a situation of a juvenile that gets convicted of a qualifying offense and has to register as a sex offender. Because sometimes people would be shocked at some of the factual scenarios. I mean, it's not, it is different. Of course, we always say juveniles are different, and they are, but this really is different. So explain some examples.
Some of the examples, and probably the most common examples, are between high school students who are dating each other, who engage in a sexual activity and someone finds out about it.
Right.
Even if it's consensual, it still can be considered a crime of lewd and lascivious battery. So all that requires is just sexual organs touching each other or engaging in a sexual act. And, high school kids, no matter what we want to think, some of them are engaging in sexual activity.
Right.
If they were to be found out, and I know there's been some recent incidences that happened that I've read about, and even in the 19th, where that type of stuff happens. That's probably the most prevalent. That
could be not only a conviction, felony conviction for a juvenile, but a sex offender registration requirement.
Yeah. That could definitely be, and that actually reminds me, there's one other exception that could apply for that, which we call the Romeo and Juliet exception.
Okay, explain that.
The Romeo and Juliet exception creates another exception which can apply to children and adults.
Right.
Where if their age difference is about 4 years apart, there was no force and there's no violation of any federal law that could alleviate their need to register as a sex offender as well.
Okay.
And a lot of times, anytime we hear about these types of stories, that's usually, especially if it's an 18-year-old with a 17-year-old high school prom, that's part of the reason why that law was created and why it has the nickname Romeo and Juliet.
So it could be an exception to the registration.
It could be.
Now, would you have to argue that in court? Would that be part of a negotiated plea? Would it be up to the judge? Well,
you can negotiate that. The prosecutor would not object to it, but at the end, it's discretionary on each judge whether it applies or not.
Okay.
So it comes down to the facts of the case and a judge looking at those facts to see if he wants to apply that exception or not.
Okay. It's, no, I think the public needs to know these are, people, and of course I'm always, this is my mantra, don't underestimate how serious juvenile court is and delinquency court is, because it's not anymore, and it follows you forever, and it's a big deal. So that's another example. Let's talk about, there's been some recent legislation, Armand, the Prolific Juvenile Offender Act, okay, that we did not think that was going to be a law that was passed, but it was. Explain that.
Well, the Prolific Juvenile Offender Act created something that some parts of the state felt was necessary.
Okay.
I believe it stemmed from over on the Gulf Coast, around the Tampa Bay area, where the legislation was, where they claimed that it was severely needed.
Right.
The problem that they were having is that there was a lot of repeat offenders. And these were repeat offenders that were waiting to go to juvenile commitment programs, sort of what would be, I don't want to say comparable to a prison, but it's sort of like a prison, but for children.
Okay. And explain so people understand, when you say waiting to go, there are certain facilities that juveniles can be placed as part of their sentence, correct, Armand?
Yes.
But we're short on beds.
Yes, we are.
Okay, so what happens when a juvenile gets sentenced to a particular program and there is no bed?
For the most part, there's 3 levels of commitment programs.
Right.
One that we call a non-secure residential, another one is a high risk, and the other one is the maximum risk.
Okay.
Before these new laws came into effect on October 1st, any juvenile that was sentenced to a non-secure residential was given the opportunity of basically being on house arrest or home detention before they got placed to their program. The other 2 programs, the high risk and maximum risk, they would be held in a detention center in their local circuit pending their placement to their program.
Okay.
So part of the issue of why the Prolific Juvenile Offender Act came to being is because these kids who were sentenced to these non-secure residential programs were out allegedly committing more offenses. I believe the statistic was about 30% of them
Right.
were out committing other property
While
crimes.
awaiting to be sentenced, kind
Yes.
of. Okay, so go ahead. So what does this new law do?
So first thing this new law does is that it makes anyone that's sentenced to a commitment program to be held in secure detention, so that they be held in the detention center for, right now, some of the waiting times that we have are about 2 to 3 months to get to some of these programs. So that they be held in a detention center until they're put into their program. The other part of the law creates the classification of a prolific juvenile offender, which sort of creates some sort of enhanced supervision for juvenile while they're waiting to go to trial or while they're waiting for the disposition of their case. That's where sort of the issues are starting to come on both sides of the aisle. One side thinks it's not strong enough. The other side says it's, well, it's creating this issue that you're putting a label on someone before they're even convicted or found delinquent in terms of juvenile cases,
Right.
before anything else happens.
But what is the criteria? Doesn't the juvenile have to have a lengthy record? Explain that.
Well, it's sort of the criteria requires that a child has 5 contacts with the Department of Juvenile Justice. What that basically means is that they've had either 5 cases that have been resolved, that they were adjudicated on, or they had a withhold of adjudication, or if they've been arrested and they're still pending disposition of their cases.
Right.
So they added that extra one there because a lot of times for some of these kids, they pick up one offense after the other before their first case ever gets resolved. So in that instance, if they meet those qualifications, no matter what the assessment or the risk assessment that DJJ prepares says, they would be held in secure detention for 21 days.
Wow. And talk about this risk assessment that the Department of Juvenile Justice puts together.
Well, unlike for an adult who faces a first appearance and they go in front of a judge based on what the arrest affidavit would say, for juveniles, the Department of Juvenile Justice does an intake. So the child would come to the Department of Juvenile Justice's detention center.
Right.
And they are evaluated based on their prior history, whatever, if they're pending another case, if they're on probation, or anything like that. And it has a point system. So basically, under the old metric, any juvenile that had over 12 points would be held in secure detention for 21 days.
Right.
Under the new system, it doesn't matter even if someone has past history. If they pick up a misdemeanor or a nonviolent offense, they would still be mandated to be held in secure detention for 21 days.
If they meet the criteria
of
right.
the prolific juvenile offender statute.
Wow. That's going to make your job tougher.
It is, and it's going to affect a lot of people in the States. I think the statistics that they did when the law passed is that this new law will affect about 300 to 400 juveniles throughout the state of Florida.
Wow. Well, and what's your feeling on this, Armand? What's your sense?
My sense is I understand why they're trying to do that, why they passed this legislation because of the repeat offenders.
Right.
But I think what it's going to create is an overflow into our detention centers, and for the most part,
we don't have a lot of beds in the detention center.
I mean, luckily in our circuits, we don't have as many as some of the others.
Right.
But knowing, based on the fact of some of our neighbors to the north, over to the west, their detention centers are pretty full, to the point that we even sometimes on courtesy supervision watch some of them in our circuit here.
Oh, okay.
So we're going to be seeing a large overflow, I feel, of juveniles waiting in the detention center, not getting the services that they need.
Yeah, yeah.
Because I can understand, to someone who doesn't understand what happens at one of these programs, that they feel it would be the same as being at a detention center.
Right.
But there aren't therapists available for the most part at the detention center. They're getting somewhat an educational service there, but really the services that they are going to their programs for, they wouldn't be getting at the detention center.
Right. Well, we're pretty blessed in this circuit to have people working at our detention center that do care about the children and that type of thing, but it's still a jail for kids.
I mean, I would be biased to say that I don't think our detention center is the best in the circuit, but just from talking to people involved, we're all trying to work together to try to get mental health services at
Right.
the detention center for these kids who are going to be waiting there for weeks on end, waiting to go to their program. So they're not just sitting around waiting to go to a program.
Let me ask you this, Armand. There's been all kinds of publicity, and believe it or not, we have like 3 minutes left. So
Oh, wow.
I told you it went fast. There's all the talk, all the publicity. There was a recent article in Sunday's paper about how juveniles are different. The science shows, it's not smoke and mirrors. It's science that the brain develops differently than it is not developed until 25, 26 years old, and there are brain differences between a juvenile and an adult. You've handled both. Do you believe that? I mean, it's science. I mean, it's fact. But do you believe that?
I don't have any background in psychology, but from what I've seen firsthand, there's been just the way that I've dealt with children and their decision making
Right.
when I meet with them. I sometimes am awestruck at the decisions that they make or how they come about making their decisions. Now I know the Supreme Court, the U.S. Supreme Court especially, is, we're starting to realize that the decision-making process for a juvenile is way different than an adult.
Right, right,
Which is why we treat them differently in the court system.
right.
But you can definitely see that their decision-making process is way different. They're more impulsive.
Yes.
They don't have the same thing that as an adult. And I know we tend to treat kids nowadays as more adults because they're maturing faster.
Right,
And on the
right.
outside, it looks like, they know what they're doing.
Yeah, so shame on them. They should know better. Yeah.
But it's understandable. You see a kid maturing faster than, someone 20, 30 years ago. You see a
Right.
16, 14-year-old that looks like they're 23
Oh, I
because
know.
they're 6'5" and they're built like a linebacker. But when you talk with them, mentally they're not at the same level as they may look physically. And
Right.
I think that's sort of where the disconnect between some people when they see a kid committing one of these acts, that they feel like they are an adult.
Right, right. No, it certainly is a conundrum, I guess. But no, I was just curious because you've done both spectrums, so it is the proof in the pudding. And
I mean, there's always the outliers. There's always some adults that act like children. There's always some kids that act like adults.
Right. Well, like you were an adult. Okay, Armand, we are almost out of time. Thank you. Obviously, if the public has, we represent poor juveniles accused of crimes, but if the public has a question or whatever, they can certainly call you and ask.
They can certainly call and ask, and we're lucky enough to have some very skilled juvenile attorneys throughout the circuit that know exactly what they're doing and are great at their jobs.
Thank you.